reflecting equity. That's where the energy is going to. So the Crown Court hears appeals from the Magistrates' Court. And basically, for a criminal matter, it's a retrial. And as we'll see, the problems really all stem from here about them not being an independent arbitrator of dispute. From the Crown Court then, basically, criminal matters go up then to the Court of Appeal. Civil appeals and that come from magistrates and county court. Then the tribunals go into the upper tribunal. But in essence, the appeal is about something went wrong in the due process of law. You feel the due process of law was not delivered. So then from the High Court, the appeals go on to the Court of Appeal, and then it all goes, Employment Appeal Tribunal goes into Court of Appeal and goes up to the Supreme Court. Now, it's the Supreme Court of the UK, okay? So this structure here applies to England and Wales, not to Scotland and not to Northern Ireland. So there's just a quick overview to give people the idea of the structure. And then this question of the court of record, the only court which is not a court of record, and by court of record I mean a word for word record of what happened in that court. Okay, and like Randall showed us, we need to clarify from the Magistrates' Court about what is the Ministry of Justice, because they've defined it as a court of record. So what do they mean by that? And all the evidence that we've got is the memorandum of entry, what was the claim and what was the decision. That's all the record that they keep. They don't actually keep a record of the rest of it. Okay, the courts have got legislative authority as well. So remember, the court system is set up through the second promise. That's where it gets its lawful authority. And some of that has been confirmed by Parliament and hence makes it a legal requirement as well. So the Magistrates' Court Act is the Magistrate Court Act 1980 is the legal authority, okay, for that. And Part 1 and Part 2 deal with civil and criminal matters. And because 90 to 95% of the cases, the vast majority of disputes are resolved in the magistrates' courts. Okay, so people can say, well, this is why it's not a court of record, because the volume just makes it irrational. We've got the technology today very easily to create our own records, and we looked at this yesterday. The right of self-defense. Who can be prejudiced? I can. Therefore, give me a reasonable excuse as to why I can't make a recording of what's happening here, because I'm the only one that can be prejudiced, and therefore I need evidence should I need to appeal.
So Mark,
yeah?
aren't we then prejudiced the fact that we have to pay for that public record?
Correct. In the rest of the courts, we're prejudiced on a socio-economic basis that I must pay for a transcript through their privileged transcribers, and they're not cheap.
No. And they can be edited.
Hmm?
And they can be edited.
And
They can be edited.
no, they can't.
But they are.
They might be.
Yeah.
So that's what that can be.
Okay?
They are.
No. Because what went on there is a public record. Any editing of what went on there is tampering with the public record,
I understand that.
and that's a serious
So
offence.
who will ever catch them out?
Hmm?
Who will ever catch them out?
if you can't record it.
Okay.
If you've got a recording.
And that's why, who can be prejudiced? I can be prejudiced, therefore fine, I will make my evidence and create my evidence and record it.
I understand.
Okay?
If you believe there's fraud or fraud may occur,
Mm.
then you've every right as a Crown protection to record it. Now I believe
You've
that-
got it anyway, because it's your right of self-defence as the only party that can be prejudiced.
so just record it.
Go through formalities, be nice, you know.
Yeah, they'll say no, won't they?
Yeah, they will.
Okay.
Why don't we try
Can
that
anybody,
No.
can anybody show reasonable excuse why I cannot record?
Ask that and then
Any
bring a film
objections?
crew in.
Hmm?
Yeah, I'll say it's bring
Ask that and then bring a film crew in with all the lights and all the cameras and all the makeup and everything.
Well, that there again comes down to reasonableness. Why do you want to record? Because you need the words to be able to defend yourself. I don't need pictures
Mm.
to defend myself. Okay? But this is stuff that we're bringing into the courts. Okay? The same like we're bringing in representation.
Can I just ask here?
Yeah.
When we went into court,
Yeah?
the six of us, my son came in as well to support me. And unbeknownst to me, he recorded everything.
Yeah?
Good man.
Okay? Yeah, good man.
Normal business.
Hmm?
Normal business.
Mm.
Okay?
So the fact that that recording exists,
Mhm.
potentially, according to the court,
Mm.
any representation I come up with based on that recording, it invalidates everything I've got.
Okay, so let's test that. If all are equal under the law, no one's above the law.
Yeah.
Okay?
That's
When
right.
police do a hidden recording, can they use it? Yes. Therefore, you can use it.
No, they're supposed to tell me that they are recording this.
Oh, what, when they go
Well,
into their
the
undercover
undercover
operations,
ones.
they sit and tell the people they're trying to entrap, hey, listen, mate, I know you're a drug dealer, you know, but I'm just recording, okay, so just careful what you say now. Of course they don't.
Yeah.
Basically, it's with the recording that your son made,
Yeah.
if there's evidence of something going wrong, okay, and this is being tested, Calvin, you have put in a transcript of the recording.
That's what I was just saying.
Yeah.
Without that
so-
recording, my whole thing will be fucked. My
Yeah.
whole thing.
Yeah.
But because I've got that recording, I've got that judge and that queer,
Good.
and that stumbling paddy, bang.
Chandelier.
Chandelier.
Okay, so basically, can they hold Calvin in contempt of court? On what grounds? He's the only party that can be biased from it. Because, but without that recording, he can't defend himself. So good luck to try and hold him in contempt of court on that one.
Yeah, I'm glad to hear that. I'm glad to hear
Okay.
this. Yeah.
But like you said yesterday, because they stream the Supreme Court and they stream all the others, why
That's
the
your
hell
common
can't-
law precedent as
Yeah,
well.
yeah,
You know, whichever way you look at it, it's
Yeah.
crazy
Yeah,
not
yeah,
allowed.
yeah.
You know, before we had the technology and going to the question about money, why do I want to pay for a transcript if I can just make a recording on my phone? I mean, it's just irrational. Hence, what reasonable excuse has anybody got to deny me recording this?
Yeah,
Oh, well, gee, well, I might catch you out lying or something. That's no reasonable excuse.
yeah.
Okay?
Just slightly different, like if we record telephone calls and don't declare that we're recording the telephone calls.
As long as it's not business one, personal one you can.
What do you mean?
So if it's not business related, you can record it. If it's
So long as you don't
commercial,
use it to cause harm, essentially, is what it boils down to at the end of the
you've every
day.
right to do
It's
it
holding people
personal.
accountable. Is that
Yeah,
correct?
yeah, so long as you're not causing harm by it. What's the difference between you and an undercover agent making a recording? Okay? Why is it lawful for them to do it and not you to do it? Either everybody can do it or nobody can do it.
Yeah.
No, it's the same argument,
If
why do
we're
they carry
all
guns,
equal
eh,
under the
so,
law.
and we don't carry
Well,
guns.
you can-
Especially
We should
recording
get
your
on
own
carry
cases,
guns.
because you can't make notes and think and speak all
Of
at
course
the
you
same
can't,
time.
especially as a
I wanna
litigant person, even the
Yeah.
barristers and the professionals can't do it.
Well, Mark, I actually have a memo from the Commissioner of Police where it says recordings and images
Mm.
actually helps the case so that we can find the facts.
Of course it does. Why? Because it's holding people to account.
Yeah.
Yeah.
As soon as people know that they're being watched, their behaviour changes.
I've got that memo and I used it,
Yeah.
and they just looked
Now,
at it.
now there's something that John Geely, who's been working with evaluation appeals, okay, he's brought it up and we need to now take this further because the Lord Chancellor with agreement of the Attorney General, can change that. They don't need further parliamentary approval. So basically, we need to put this case to them and say, Supreme Court records live streams, downloadable. Appeal Court does. Okay? Why must we pay for a transcript? Because that's in breach of the Statute of Monopoly 1623. And why can't we record in the magistrates' courts? Because we're the only party that can be prejudiced. Okay? Let's bring it to court. Let's do it. Okay? And so this is something I'm working with John on. Okay, and we've said in the magistrates' court, in every tribunal, the rules of equity prevail. Because every lower court is bound by the higher courts. Okay? So when they say that we're not courts of equity, Earl of Oxford case is binding on the lower courts. So part 2 is civil matters, and then part 2, what it says is, unless Parliament tells me I can't. That there is a direct interference with the running of the independent courts. Hence, why we should be able to go and bring our money claims in there for 50p or £3 or whatever, or a few pounds compared to hundreds of pounds. Why we should be able to get the binding over orders, which is a cease and desist. It's a injunction. We should be able to get this for pounds, not hundreds of pounds or thousands of pounds in the magistrates' court. So, did somebody send me the court internal manual, or did they send it to you and you sent it to me, or I sent it to you?
The magistrates one?
Yeah.
No, you sent it to me.
Okay, somebody out the blue sent me the magistrates' court's own manual about their internal procedures and how they operate. So we're quoting from that back to the magistrates' court saying, yeah, in your book, in section 6 or 11, whatever it is, this is what I want, a binding over order. How do I go about getting it? Why am I not getting a response? Okay, so we need to take it to them, to force them to do their job.
Have you FOI'd the Ministry of Justice to ask them?
I mean, Dwayne's been pushing it more, but basically we'll get there. It's a matter of time.
I don't mind putting it on the FOI if it hasn't been done.
No, and it's their own manual. It's the Act of Parliament says.
But if you get an FOI
Actually,
from
ask
the
the
Ministry of Justice
Justice.
and take it into the magistrates' court,
Actually, if you don't mind, do an FOI to the Ministry of Justice and say, in accordance with the Magistrates Court Act 1980, Part 2, it says civil matters, and in section whatever it says binding over orders, and in your manual it says part whatever binding over orders.
I told you about it. I'll get the
I've been trying to do this. Can you please tell us, because none of your magistrates' courts seem to do anything with it. Okay?
Can I just,
That might be
this is
covered under freedom of
technicality here. It's 109.7 here. I've got 107.7. So somehow I
I
don't...
don't know how to do it.
You might have the updated
They've
version.
got to have the information about
right, okay.
Okay.
How can they do it if they don't know how it's done?
More like a question of how many times has it been done on?
Yeah.
Okay, so essentially the problem with magistrates' courts and council tax now, I've got an FOI back from the Ministry of Justice that says in council tax matters, this is what the council must prove in the court. And guess what? There's no my obligation on that. That there's the Ministry of Justice saying, hey man, this is our administrative court. You know, it's insane what's going on here. So, well, thank you for confirming that every single council tax liability order is unlawful. You know, that's what they're saying. Okay? But wherever a court follows a procedure set by Parliament, that is proof of bias. The court not being independent. Okay? We need independent courts where anybody can go to resolve dispute, because we're all equal under the law, nobody's above the law, and no one can impose their will, and no flippin' group of muppets, doesn't matter if there's 650 or 6,000 of them, can tell 67 million people what to do, let alone tell any one other person what to do. Okay? So we went through yesterday and we were talking about the, trial by jury versus trial by judge, basically written, logic, reasoned
In order.
decision. Okay? Those of you that do believe that trial by jury is better, okay, the Bill of Rights says you're entitled to a jury trial. So if they don't uphold that right, appeal.
Or anything.
On anything, a fine, no fines, forfeitures without the due process of law. Okay, we saw yesterday, we looked at that under the court's own rules in the magistrates' court, they must give you a reasoned judgment. We need to start holding these guys to account. So when they say I'm going to fine you so much pounds, okay, can you explain and show me your reasoning how so much pounds reflects the harm caused in accordance with your obligation under Section 63 of the Sentencing Act 2020? Okay. So one of the questions you ask is the CPS, okay, you want to fine me 500 quid or 1,000 quid because I'm driving without an MOT or because I was speeding or whatever? It is. Mr. CPS, can you please confirm to the court the harm that was caused? If you can't do that, and you want to force that into the evidence, once it's forced into the evidence, therefore there can't be a fine for it. Okay? So, in the new council tax thing, what we're doing is putting all of this into our notice. Because what we're saying to the council is, hey listen, the courts are carrying out unlawful administrative courts on behalf of Parliament assembled. By you being with this knowledge now, should you apply to the court for a summons or a liability order, you now are complicit and knowingly committing an act of fraud. Okay, so that we can try and stop them bringing in these things into.
When you say them, somebody from the council must sign as the complainant. We need to get that document. Who is, or ask?
No,
who is the complainant?
they tell you who complains on behalf of the council. A
Well,
complainant.
No, it's hard to find. You don't know unless you ask.
It's the 151 officer.
No, it's not. No, not in my case anyway.
But you can find that information out.
Right. But all I'm saying is that that's the person who needs to know that she's signing this as the complainant. She's going to be the one.
But again, this is where we start to use the legal fiction to our advantage.
Okay.
Notice, principal notice to agent means anybody employed within the structure of the council, anybody.
So the CEO's got a copy.
It makes no difference.
Well, someone's got a copy.
With notice to principal, notice to agent, the fiction is noticed and is with the knowledge, and therefore all its actors must act within the knowledge of the fiction.
Okay.
If the fiction doesn't pass that knowledge on to an individual actor, okay, it's not my problem, not your problem.
So then if you did bring a claim, who would you bring the claim to?
The actual person that is taking
So the claim.
making that laying that information or making a complaint.
I'm on about council tax.
Yeah, with council tax.
Right.
Whoever actually makes that complaint.
Yeah, okay.
Well, the person at the court that represents the council.
No,
Or
the person that signs the piece of paper to and gives it to the court, making that complaint.
In the bar
I
court.
don't think anyone does, do they?
I know they do.
No, they have to. A fiction can't act.
Yeah,
It
yeah.
only can act through its agents.
Yeah.
Some living human being must have done that.
I'm going through one now. I've
Yeah.
got one coming up, my council tax.
Yeah.
And the complaints been made
Yeah.
by CEO of Finance, Christina Thomas, and she's signed it off as
It could be somebody in the council an agent of the council has made that complaint.
Mhm.
And that person
That's
is individually liable for that complaint. They took the action.
Because they have to apply to the court
Yeah.
to be able to issue the summons and then reapply again for the liability orders afterwards. So I've got a piece of paper where they've signed it as complainant.
Okay, now, Section 101 of the Magistrates Court Act has been where a lot of our problems, I think, have stemmed from. Now, what that says is, if I'm bringing in a claim under this, the complainant, or the person bringing the case, does not have to prove anything. You have to prove this doesn't apply to you. That there is a total admission of bias, okay, and the abuse of the due process. So anything brought where they say, in accordance with legislation, okay, that Section 101 says you must prove it doesn't apply to you, i.e. you're guilty and must prove you are innocent. Totally against the fundamental concepts of law. However, this again, we've been using to our advantage, because using this, we're saying, well, the Bill of Rights is current statute law, it says this. The Act of Settlement is current statute law, it says this. The Coronation Oath Act, current statute law, it says this. Therefore, now you need to rebut what we're saying. So, again, even though it's saying you're guilty and must prove you're innocent, we can use this to force them to respond to our legal arguments. So, again, there's always a silver lining to this stuff. So, that's all I want to sort of say on the Bill of Rights other than this section. What happens is, they send you a belief, and what do? They send you a single justice notice procedure, and they say, how do you plead? This is the only place I can see where you're creating joinder. Because by entering a plea of either guilty or not guilty, what you're saying is, yep, I'm guilty of the act that you have said, okay, or I'm not guilty of that. So what you're saying is the legislation you've quoted has power over me, but I'm not guilty of what you're accusing me of. Okay? So what we've done is we've tested this in a different manner and had very positive responses. So what we did was Manchester Police was trying to get a £10,000 COVID fine for Debbie as well. She had 3 or 4 of these bloody things, for not going into a hotel coming from a red list country when that was legislation. So what we said was, I'm unable to enter a plea as there's no lawful cause of action. No sentence, fine or forfeiture can be imposed in accordance with the Sentencing Act 2020, as no evidence has been presented in accordance with Section 63 assessing seriousness, where the court has a legal obligation when considering the seriousness of any offence, it must consider any harm which was caused, intended to be caused, or might reasonably foreseeably have been caused. Further, the court has no authority to impose a fine or forfeiture unless a jury so decides in accordance with the Bill of Rights 1688, therefore there is no case to answer. Okay? So what happened was, we put this in. 2 days later, the trial was listed at a local court, not in Manchester, with a response saying, before a district judge, with a response saying, we don't understand what you're saying. So when we went to the magistrates' court in Wirral, we put in a power of attorney, and 3 minutes before we were scheduled, I think it was 10 o'clock, so just before 10 o'clock, the clerk of the court came out and said the Crown has withdrawn the case. Okay, so we're trying different stuff, and until we find a consistent thing, but I think we're starting to hone in on how to deal with these frivolous claims. So you can use this for speeding offences, you can use it for parking tickets, you can use this for anything. Same thing. Okay? So,
Mark, what do you do, say for instance,
yeah.
Victoria and Richard that were, so they got busted for DWP stuff and the police came and arrested them, dragged them off to Woodgreen Crown Court and said to them, how do you plead? Well, bearing in mind that they've just been arrested, so they don't even know what the charges are, other than they just read
So
out.
you just can't enter a plea, can you?
So that's what they said.
Show me the evidence, show me the charges. Once I've got the evidence, then I can enter a plea.
So then they get thrown downstairs in the dungeon for 4 hours, brought back out. Are you ready to make a plea? Guilty or not guilty? So they said again, can I have a pen and paper? Threw them back down again.
That sounds like that's it.
Yeah, no,
Oh,
but,
yeah.
but so basically, if you, Mr. Magistrate, are holding me in contempt of court, I now want the appeal heard before you proceed any further in this matter.
Yeah.
So you have the right to appeal a contempt of court.
But then they say
It needs
if
to
you
be a
don't-
different judge, and you simply turn around to the other judge. They've not shown me any evidence.
But they also say if you do not plead, I will plead for you.
Well, you can do what the hell you like. It's not binding on me.
No, but they're going to proceed. I mean, because you know you.
Yeah. Okay. You,
I had a
according to the
situation like that.
rules.
Yeah.
I had a situation like that where I went in to represent a young man, and the judge was forcing him to make a plea.
Yeah.
And I said to him, you can't make any plea because you haven't been given the information. I said, furthermore, who is the claimant?
Yeah.
Which was the CPS. I said, do they have first-hand knowledge and are they a witness?
Yeah.
The CPS never spoke another word
Yeah.
in the whole case. So the judge now was trying to force him to make a plea.
Yeah.
So I said, hey, if you force him to make a plea, then you must take the liability.
That was
Yeah.
for contempt, because
You can't.
party.
Yeah.
And one thing
Yeah,
is
but this is the
show
thing,
me
we're
how to-
learning, okay, and we need to experiment and what works, find out what works and what doesn't work, and make sure that we find something that consistently works.
According to the Archbold, they can only, or if the judge believes you're mute or belligerent, they can make a plea for you. But then reading elsewhere, it's like you say to the judge, show me the power of attorney, by which gives you the rights to make a plea for me.
Correct.
So, you
No,
know.
absolutely,
Yeah.
and the same thing, you enter a plea,
Yeah.
it's your liability, not
Yeah.
mine. You've taken responsibility. Okay.
But
But,
that's also where you can ask the question, can't you? I mean, ultimately, it's all about, like you've said before, asking questions. So if you say to them, enter a plea, like, you know, it's all bullying, isn't it?
of course
That's-
it is,
Yeah.
it's distraction,
So
intimidation.
straight up harassment, intimidation,
Yeah,
and
yeah, 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 yeah.
everything's just fake, so.
Yeah.
That's where you
You
need
could
to have
ask
a recording.
By creating joinder by entering a plea.
Yeah, you
Is
can.
it criminal?
No,
Is
absolutely.
it civil? What, you know, what is it? What is it? What
Okay.
action do you feel?
With costs, like I said before, costs are discretionary, okay? The nice thing about the employment tribunals, the cost rules are different, okay? Costs are only made when somebody is obstructing the due course of justice, i.e. each party bears their own costs. So if you are obfuscating or anything like that, acting in dishonour, that's it. If you're creating costs for me because of your dishonour, I actually will get my costs covered. Okay? So it's in the tribunals now, already it's moved to equity. He who creates the obligation, okay, must provide the remedy. Okay. Right. Okay, a few of the rules, what I've got in the manual is the links to the civil procedure rules and the criminal procedure rules. And I just want to talk about a few of them. I'm not going to talk about many of them. Okay? But essentially, the generalities which apply, which I've talked about so far already, is all parties must have all the same paperwork, i.e. service needs to be to everybody involved in the case, so that everybody's reading off the same page.
So there's no surprises, yeah?
Hmm?
So
No
there's
surprises. Okay, what's the surprise? Unclean hands, bad faith. And the designated officer, the court can ask them to keep the court file. So the council actually is the designated officer of the court, which is why they keep all the paperwork and the court doesn't. So it's perfectly lawful. What's important though is the court knows where and how that information can be accessed. It does not absolve them from certain responsibilities though, okay? So,
So Mark,
yeah,
so because the council is holding it,
yeah.
when you go through the court, must the court talk or they're just going to keep directing you to the council?
So if I want a liability order, as far as I'm concerned, who's created the liability order? The court. I talk to the court. They need to sort out their internal crap to make sure that the court gives me what I'm entitled to from the court.
Can't you just issue the council a liability order for their obligation to pay?
Absolutely.
Anyone can issue a liability.
Of course
Just
they
give them a liability order, say show my obligation to pay.
I mean, what I've got from the Ministry of Justice is
Yeah.
they don't produce a liability order.
Well, that's in breach of their obligations because the rules say they must.
Yeah, so they
So
said,
they must.
so they said
Bottom line.
they issue, but they do not produce.
No, generate. So they've issued it and it'll be on the memorandum of entry.
Yeah.
That's where it's only found.
That's
two
the
nights.
only record of a liability order is on the memorandum of entry.
Look at the definition of
And
issue.
you ring up and you say you have to pay a tenner for it, which is worth it because you've actually got a record of you paying.
Well, in fact, it's actually, shouldn't even be paying a tenner because guess what? If there's a liability order issued against me, right, I've paid the costs, therefore I've paid for the liability order. Now, give me that liability order.
Right.
I've not received the original one yet. I don't need a copy. I want the original. I've not been served it. So this is again what we're trying to do, and people are trying to get the memorandum of entry because that's the only legal proof of a liability order.
And that's the thing.
So we shouldn't have been paying for a copy for basically.
No.
I mean, I don't know anyone who's ever seen a liability order.
Yeah.
Well, I've got the memorandum of entry,
Yeah.
just like a spreadsheet, and
Yeah.
it just says, you know, the case number.
Yeah, I can
all
show
it
you
says is
afterwards.
liability order made.
Mm.
Yeah,
The
I've seen that.
Oh, okay.
But
That's
I've never
it.
seen their liability.
No, that's it.
Yeah.
That
That
is
there
it.
is legally
It's got your
a
name.
record of the liability order. It's not the liability.
Yeah, that's.
Yeah.
But under the freedom of information,
Yeah.
the council tax have the rights to generate it.
Okay.
But when they generate it says notice of.
Yeah.
Yeah, a lot of them say notice. Some of them now actually have stopped saying notice. They're just saying liability order. They're all just reacting all over the show with all sorts of nonsense. Okay, section 14 is important in the Magistrates Court rules because that tells you the due process, what's going to happen. So a summary trial, basically, if the defendant appears, okay, then the due process is first the complainant gives their side of the story, then the defendant gives their side of the story, and based upon that, the decision's made whether to uphold the complaint and grant them their wish or dismiss the complaint. If the defendant does not appear, but you can prove service, the court can proceed in the absence of the defendant. If the complainant doesn't appear, basically the court can pick or choose what it does with it. If neither the complainant nor the defendant appear, they can pick and choose of it. Okay, if they do attend,